started. I'm going to sit down in a second. My name is Tim Alger. I'm a partner at Perkins Cooley LLP here in beautiful Palo Alto. I practiced civil litigation for traditional online companies for many years. And let me introduce my panelist, Daphne Keller, who's the legal director at Google and a former co-worker at Conwell's in-house at Google. And she will describe what she does. Now you have responsibility for what relates to takedown policy, right?
I do more external advocacy than that. So like fly Europe and tell them why they shouldn't make intermediaries silent speech without something to
And then Cindy Cohen, who is the legal director. Actually, you're the top lawyer, right? For litigation, you said you have that. Is that correct?
Yeah, well, Sherry Steele's a lawyer too, but she doesn't practice that. And I came late to a board meeting once, and so now I'm a general counsel. I feel like
So Cindy's in the center of all the action over the AFF. Then we have David Gingras, who is a private lawyer in Phoenix, but he's most well known as the general counsel for Ripoff Report.com, and he also represents The Dirty. They're both of those sites are making a lot of news on the Dirty, so we'll hear some stuff from David today. And then Chris Sundermeyer, who is general counsel at Reputation.com, and he can describe a little bit about what Reputation.com does when we get to him in a few minutes. Very interesting work that they do, and it's not necessarily obvious what they do, so we'll talk a little bit about that today. We have a little bit of an outline. We've got a lot to cover, but I promise the panelists we won't use the outline as a straitjacket. We'll bounce around a little bit. So I think most of you have functioned in the space for quite some time, so we won't spend a lot of time on it. Just to lay the table, set the table, you know, we're dealing really with demands to take down user-generated content. And outside of intellectual property, that's of course controlled by the Communications Decency Act, Section 230, which provides an absolute immunity for intermediaries of publication of user-generated content. There's some exceptions, and the biggest exception, which we'll focus on a little bit today, is intellectual property claims. And so that accepts out copyright and trademark. So then moving on to the copyright world, we've got a statutory scheme set up with DMCA, and that has a safe harbor. If the owner of the claims owner of the copyright gives notice, then the intermediary, the overgeneralized, can avoid damages liability by taking down pursuant to a request. The request needs to be specific. I think the courts have been quite clear on that now. There are exceptions to that as well, including possible common law inducement liability, since it used to be banged around in the courts. So we've got a notice and takedown provision with the little scheme in the DMCA. And trademark, who knows really? It's really kind of I think you'd say it is essentially a common law notice and takedown obligation. We'll talk about that a little bit today. But we've got this situation now where sometimes claims that are being brought under the Lanham Act, they're probably more closely aligned to a defamation claim. They're being used, people are suing under Section 43A nowadays, so that's the latest. And then some courts, some confused judges have concluded that right of publicity claims are intellectual property rights. That's an exception to the CDA. I think that's really misguided. But we've got a couple of district court decisions out there on that. So the first thing we want to talk about today is we're going to ask Daphne to talk about it because she has a good general lay of the land, given her role Google plays both as a search engine and as a host of content. What kind of takedown demand does Google do?
Every kind of takedown demand. So do you want to talk a little bit about the difference between search and other products? Google has roughly two buckets of products that probably represent likely legal removals models that other companies might have. So on the one hand, there's web search, which is the product I was the lead lawyer for a long time, and I love it. Web search tries to leave stuff up if it's legal. And so when a removal demand comes in, the question is, does the law require us to take this down? And that can be a hard and interesting question, and especially once you add an international dimension. But most of our other products, the hosted products, have another question, what's actually a first order question when a complaint comes in, which is, do we want to take this down under our own discretion anyway because it violates our policies? And realistically, a lot of internet companies are going to be in that bucket, because what you're trying to do is operate a community. You're trying to create a space where your users can interact with each other without having the hardcore porn page or the super duper hate speech page. You decide what it is you want on your site, and you have discretionary removals, community guidelines removals, we call them, for that site. So much as I love web search and standing up for users and turning to the law, the community guidelines removals can be a lawyer's best friend, because when you get a really troubling letter in the middle of the night saying the following is pornographic under Indian law and has to come down, well, if it has to come down anyway under your community guidelines, then guess what? You're not researching Indian law that night, right? So community guidelines, super helpful. One thing I would flag about community guidelines, kind of not the lawyer's job, doesn't have to be done by lawyers, but it's something as a lawyer you want to pay attention to, because if community guidelines are being enforced inconsistently, it's bad for your reputation, it's bad for how users look at you. It also creates a little hook in the DMCA space for someone to try to say, oh, you're exercising right and ability to control. I don't think they should win on that claim, but it's a little extra area for a plaintiff to come after you. Similarly, in Europe, the e-commerce directive has something called the active hosting doctrine. It looks like you're mucking around with the content and exercising discretion in an inconsistent way. That does not help you legally. Tim asked me to talk a little bit about sort of setting up processes. Some things that I would throw out there, and this is kind of me being professorial, not specific to Google, but Elizabeth Valentina mentioned earlier meeting your DMCA prerequisites, register an agent, register an agent, register an agent. Like, don't screw that up, because you can lose your whole DMCA defense over a little logistical hoop. Same with having a repeat infringer policy. You also want to have a smooth path for complaints to reach the lawyers, and what that looks like will vary with the size of the company. That's externally a web form, an email address, something that makes it easy to get the complaint into the company, and internally a way that, if a cease and desist letter from Sweden lands on your CEO's desk and bounces around like a hot potato from one desk to another, you want an alias or something so that people internally know how to get a legal complaint to you quickly and you can act on it. So some other kind of best practices, what I think are best practices, have a transparency report. Have a way that you tell users what is coming down. That's not required by the law, but it's something that is an increasingly standard practice. Microsoft does it, Google does it, Twitter does it, Dropbox does it. It's a mixture of, that list covers a mixture of police requests and removal, or user data requests and removal requests, but having some way you disclose to users what it is that's coming down off the internet, very much a best practice, makes a difference in user trust, and so forth. The final thing I'll throw out, I could go on about any of these for an hour, but I'll cut short. It's sort of monitor your hotspots. Know where you're seeing a lot of frustration with removals, and evolve or don't evolve. Make an informed decision, but understand where people are getting frustrated regardless of what the law says. And so this is where Google wound up building Content ID for YouTube. That's not something the DMCA requires. It's not something any law requires. But it's something that helped to forward the product, helped get rid of piracy, and so forth. Similarly, the Trusted Partners Removal Program for Web Search, which is sort of a fast-track DMCA program for people who have volume piracy complaints and who have shown they're not abusing the process, is sort of not required by the law, but something that's an evolving response to where the pressures of the rights holders are seeing.
I have a question for you, a couple of questions.
Yeah.
By the way, these are not rehearsed. So the issue I want to talk about discretionary removals based on the guidelines, and also the issue of content ID type, automated matching. In reverse order, on the YouTube situation, by having automated tools, which Google developed at great expense, have we set a new standard? In other words, we contend in our litigation that this is not required, it's voluntary, the DMCA gives us great protections. Have the tech companies, by implementing these tools, essentially set the new standard, and is it affecting how the internet companies are able to defend these cases?
So I think the answer has to be no, because if that were the new standard, there could never be startups anymore, right? Content ID was massively expensive to build. It's not something a startup can build out the gate. It's something that DMCA says flatly is not required in 5.1, and it's also something that the e-commerce directive, with a more arguable loophole that has 2.5 times been rejected by the ECJ, e-commerce directive says it's not required. So it's not setting a new standard. It is going above and beyond the call of the law, and it's not something that could realistically be expected of every company.
So then my second question was actually my first, and that is, I'll give you a little anecdote. So on Wednesday, I was in the Ninth Circuit arguing on behalf of your client on to take the issue of whether Google and YouTube had an obligation to take down the innocence of Muslim video in a trailer that sparked riots in the Middle East. And the first question out of the box from Judge Kaczynski, by the way, this is a copyright case. The actress says that she owns a copyright for 5 seconds of performance of video. Judge Kaczynski, the first thing he says is, Mr. Aldry said, why don't you just take it down? He said, doesn't Google have other things to do with its money besides spending money on lawyers? That the woman says she's insured for her safety, and you guys have the ability to take it down. So I guess my question is, given the fact that we do acknowledge our clients, do acknowledge we have terms of service and we have the right to make discretionary removals based on terms of service, does that perhaps color us in the eyes of judges who are saying, well, then if you're able to do it in that situation when there's equities, should we be able to kind of hide behind the technicalities?
You're taking your hardest Kaczynski question and asking me.
Yeah.
So the fact that I feel like that illustrates exactly why you shouldn't do it. You shouldn't be bending your policies and taking things down even though they don't violate your policies as one-offs to help individual people, because that's what tells judges that you can't be trusted, that you're not consistent, that you might as well just take it down. So I think that just reinforces the importance of having consistent policies and not making special exceptions.
Cindy, you told me that day when we were chatting that you take the consumer's point of view, and I assume you advocate on behalf of people who don't want it, right?
Pretty much, yeah. It's rare that the content industry comes to us and asks us to help them. Yeah, I mean, what happens at the end of the process between the content owner and the intermediary is somebody if somebody gets censored, then they tend to call us. And I think that a lot of, what we worry about a lot is that intermediaries kind of feel like this is a two-way discussion between them and the content industry, and forget that, feel the pressure from the content industry. As Daphne said, they're responding to pressures. And of course, the pressures in this instance aren't coming from your users, because your users just want your service to work. And they don't tend to have the union of people whose stuff has been taken down, right? And they don't go to Congress, and they don't beat you up in congressional hearings. And so we try to, at some place, in some way, and we're not the only ones, try to be a voice for the people who are kind of otherwise voiceless in this debate, which is the people whose speech is coming down. It's why I'm not a big fan of content ID and all the other voluntary things that the industry tries to do, and I'm not a fan of them for two reasons. One is they don't appear to work. It's not like the content industry decided to drop their case against YouTube as a result of content ID. They never are satisfied. Because I don't actually think it's about infringement, it's about controlling the technology companies. But even if I'm wrong about that and way too cynical, having done this for too long, it doesn't appear to me that there's any evidence that the content industry has ever been appeased by anything that an intermediary has done to try to make their life easier with regard to takedowns. So if you're looking for an evidence-based decision-making, I don't see it. The second thing is that Congress wrote a law about when somebody else gets to censor your speech on grounds that it might be copyright infringement. And it set a bunch of rules. And so I'm a little frustrated that that wasn't enough. That, basically I think what's happening is an industry that didn't get everything it wanted through the legislative process is trying to bully intermediaries into getting what they actually wanted. But that's not how it's supposed to work, right? It's supposed to work that the Congress writes the laws and people follow the laws, and that's the rule. Now, I'm not saying that you can't, have community standards within that, but to the extent you're having community standards because they're based on trying to appease a particular industry, that's not actually community standards. That's trying to appease a particular industry. I get, if you've got, let's say your J Day and you want to keep it to just J's, you might do some things about your community to make sure there's only J's involved. I get that, but they don't actually do that, but that's just an example. But what we deal with is people who come to us because their materials have been taken down. And I kind of talk through, I think these processes, and we see a lot of misuse of the takedown processes, both the content ID, the informal ones, and the formal ones. We have a thing called the Takedown Hall of Shame. We just had our our inductees in May. In May, we did our Hall of Shame inductions. We've got a Louisville-based company called Kern's Kitchen that claims that it owns the rights to Derby Pie. If you've never had Derby Pie, you should try it. It's a chocolate pie with pecans on the top, really tasty, and not ownable by someone. We made a very hilarious video called The Mean-Spirited Censorship Pie, if you want to see a video response to that. There's a company called Cater's News, that is trying to claim copyrighted photos taken by a monkey. It's great. You want to see the photos?
I was intrigued at one of your recent additions to the Prince entry that he's now complaining about 6-second videos on Twitter.
Yeah. On the Vine thing, he's calling. Yeah, Prince has what we call the Raspberry Beret Lifetime Achievement Award. We have nothing. It's nothing if not fun to work together. Let me tell you. And of course, Prince is he's not the copyright holder, but I believe he is one of the forces behind the case we're currently litigating in the Ninth Circuit involving the mom taking the little video of her toddler, who is now in school, by the way, toddler running around the kitchen with Prince's Let's Go Crazy in the background. So, we not only try to shine a light on bad takedowns, we take a lot of cases and handle a lot of litigation around this. And one of the things we've tried to do is to breathe some life into Section 512C, which is the section of the DMCA that allows you to bring an action to somebody for creating a false F. Sorry, got my numbers confused. 512F. Unfortunately, there was a bad Ninth Circuit decision a couple of years ago that kind of gutted Section 512F, and we're trying to bring it back to life in the Ninth Circuit. The Ninth Circuit just accepted cross appeal from both us and Universal Music. Universal owns the rights to Let's Go Crazy, the Prince song. And that's going to be briefed over the summer and heard by the Ninth Circuit. And we're looking forward to trying to really undo some bad stuff that was done by a case called Rossi. In that, in terms of kind of going to, Daphne kind of gave some best practices, and let me add a couple of my own from where we sit. One of the things is that as somebody who's trying to help people who have takedown notices, there are far too many systems, and I'm sad to say that YouTube's and Google's is one of these, where I can't actually get a hold of the takedown notice. What I get is a notice from the intermediary that says somebody has actually complained about what you've done, and for many cases, my clients don't even know which one of their things was necessarily the problem or why, and what the claim is. I had a whole bunch of cases where I helped people who were making American Sign Language versions of popular music. People with cochlear implants can now hear music fairly well, but they have trouble with the words, and there's a lot of efforts done by volunteers to take music videos and do them with American Sign Language. they get caught by content ID. Why? Because it's the music, right? But no one's not going to watch Gnarls Barkley's video of Crazy and instead watch my guy, who's actually hilarious, doing his version of Crazy with the ASL. He's actually quite good. When I say no one, I mean no one, who's not a copyright geek. But we had the hardest time trying to figure out which of his videos were the ones that were problematic, because he'd made a whole bunch of them, and he started getting these takedown notices. But actually, I mean, just a straight up lawyering, like seeing what the demand letter looks like is kind of important to figuring out what your response is. Unfortunately, the automated systems that intermediaries of a certain size have done don't give them that basic information. So that I think is really important. I think restoring promptly when the counter notice period expires is important. We've handled a lot of cases, especially involving political campaigns and other stuff that's time dependent, where it seems really clear that the copyright process is being used to try to take something down just long enough until the election passes, right? And so timing may not seem like it's important often to the intermediary. Sometimes in the election ones it's obvious, but sometimes it's not obvious to the intermediary. But making it really timely in terms of putting back up is really important. Having what we call a dolphin hotline, some place to really have a way to kind of draw attention to situations that might be fact dependent. And one of the things that's wonderful about being anti-FF, but frustrating to me as somebody who thinks about systems as a whole, is that I actually know who to call at Google and at some of the other companies to get stuff put back up again. But you shouldn't have to know me or know Daphne to have your speech not censored improperly, right? I mean, that's kind of a broken thing, not a fixing thing. But if companies could try to figure out some systems where it's easy for people who really have a legitimate need to jump out of the queue to jump out of the queue, or a queue that actually moves, either of those is okay, that would be really helpful for us. So there's many more things I could say. But
two questions for you. First of all, I assume that you have exchanges. You talked to some intermediaries into putting materials back up on an informal basis.
Yes.
Not just the MCA notice, counter notice situations where you've reached out and said, we should put this back up.
Absolutely.
Right, and you've been successful. Has that always been on an informal basis?
Well, we
set aside copyright for a second, and just look at counter notice.
Yeah. Well, I mean, our best thing, even outside of copyright law, is something called the Streisand Effect, which is Barbara Streisand made this very famous because somebody flew over her Malibu estate. This is a guy who flies over lots of places and offers pictures for sale. He routinely got about 5 or 6 people looking at his website after he did it. But Barbara Streisand threatened to sue him, and he had actually filed a suit. I don't remember how far that got. It was a long time ago. Yeah, she filed a suit. Yeah, and the case, far more people saw Barbara Streisand's backyard as a result of this, like millions and millions of people saw her who did it. And so one of the things that I get to use and I point out is that, you're not going to look so good if the FF logs like this or if it gets to the press. And maybe you ought to talk to your client about whether you want this kind of attention. Of course, the biggest example of that in recent times involved the oatmeal, the website oatmeal, where a lawyer who threatened the oatmeal resulted in the oatmeal raising, I think, over $1.2 million that he gave to the American Cancer Society in response, and put the guy's stuff up, and oh my, it was a tremendous example of the Streisand Effect. So one of the things that I have is not only the goodness of my heart and the goodness of pointing to the goodness of the heart, but is to say, this is going to get you the kind of attention your client does not want.
That sounds like more threatening than waving the First Amendment flag. Are the tech clients, I'm just curious because I originally represent newspapers and so forth, and we were always conscious of our First Amendment obligations to keep the public informed. And I often, now, practicing in Silicon Valley, I don't necessarily feel that that's the primary driving force for a lot of our clients. Does the principle of free speech, does that come into play when you get on the phone with these folks?
I'm sure. I will say it's, but my job is to make the speech stay up, and so I will use the techniques that are appropriate. And certainly it's not, I don't think it's telling somebody the truth about what's going to happen coming down the road, maybe a threat, but in this instance, I mean, it may not be me, you know, it might be Declan McCullough or David Kravitz that comes, or Mike Masnick who gets a hold of this thing, so, you know. But yeah, certainly I appeal to people's sense of the First Amendment, but most people who are intermediaries are, that might not be their primary goal. And certainly they have the right, generally, and we will support this, especially if it's their terms of service, they tend to have the right to take anything down. I mean, they don't have to host anything most of the time. I mean, there's a pretty rare example. So you have to appeal to something more than just the, you know, as a patriot and a defender of the First Amendment. And sometimes you can, but usually they've made a mistake, and you've got to help convince them that they've made a mistake and they need to fix it.
Have you ever gotten a tech company intermediary to change their policies? I get the idea of particular takedowns and then reposting. Have you ever gotten anybody to actually change policies?
Probably. I'm trying to think if there's a good example. I mean, certainly some of the stuff that we did some work with the National Coalition Against Censorship, trying to help some tech companies develop better standards for how they decide whether something should be taken down on the grounds of nudity or other things. There was a problem, and I'm trying to remember if it was YouTube or Facebook, taking down art. You know, things that were in museums, but that also featured naked people, or movies that were art movies of it. I mean, stuff that you really would see in a museum, and to try to get them to be. And the National Coalition Against Censorship does this a lot, is help people kind of think through how it is that you decide what is art and what is pornography, and we partnered with them and helped kind of get them into a conversation with companies to try to think about how you do your training a little better. Of the people who have to go through all this stuff. Certainly on transparency reports, on lots of things. I mean, we do a lot of work on intermediaries to try to do a better job standing up, a good job standing up for their users. And I think through on the law enforcement side, our Who Has Your Back thing, where we track companies, whether they give transparency reports, whether how they react to law enforcement. That we give gold stars to companies. I think that's been a nice catalyst. I wouldn't say that, it's hard to say what resulted in the change. I think often we help amplify a voice that's already going on inside the company, and we help give them some external validation that if you go this way, you are doing the right thing, and it's worth doing this way, because sometimes I think I get the sense that inside the company that might be a harder sell, and so we help mirror and amplify certain voices. I doubt that there's a single company out there that's ever done something solely because we thought we suggested it to them. I'd like to think we have that power.
Can I jump in to agree with Cindy on 90% of what you said? I mean, so we're all lawyers. We're used to this adversarial process where there's an accuser or a plaintiff, and there's an accused or a defendant, and there's a judge. And then they all argue, and then there's a result. But the scenario Cindy's describing and I'm describing only has two players. It's got an accuser, and then instead of a judge, it's got us. It's got a random tech company. And that's not who you want making your legal decisions for you as a general matter, which is why in the US it's great that there are things like CDA 230 that take that out of our hands and put it in the hands of an actual judge. But if you look at countries like the rest of the world, that's not the case. And there are situations where as a tech company you get an accusation and you have to say, weighing the free speech defenses of Japan against the privacy rights of Japan and the facts that I can't possibly know, here's my conclusion. And that's a pretty broken system, and that's why it's much better to have a law that lets you either go to a judge to resolve that, because there is that, or at least go to the person who posted it in the first place, because that's the person who knows the facts and can explain them. They know the relevant legal defenses in their country, certainly better than we do. If they are infringing someone's rights, they can fix it. They can fix it at the source so that it's not out there anymore. If they are infringing someone's rights, they can fix the one sentence that's infringing someone's rights and leave the rest up. Whereas a host can only do this binary switch to take the whole thing down. So there are a lot of reasons to, and by the way, there's abundant evidence that intermediaries do exactly what you think they do, which is they get an accusation and they just take it down, right? Because why invest the money and the risk in doing otherwise, although that's my job. But my point being sort of to what is the best possible law? A law that stops tech companies from pretending to be judges is the one that's going to protect user speech and access to online businesses and so forth.
Okay, so then let's kick the ball down to Chris down at the end. So what's Reputation.com, and are you in the business of doing takedowns?
Well, we're certainly not in the business of doing takedowns. We are an online reputation management company. Our goal is to provide a variety of tools to individuals to shape, improve, or create your presence online. And that means anything from, we have a whole variety of tools that help people eliminate some of their private personal data from the internet, from the data ecosystem, as well as people who maybe want to shape their review presence online, anywhere from businesses. Sort of the core of the history of the business historically has been, in part, however, what we call our sort of reputation defending product, which is really sort of the antithesis to all of this, because it starts from the assumption that you're not going to get the stuff taken down off of the internet. And so, although Cindy says she represents the consumer's interest, on some level she doesn't represent the consumer's interest. We represent consumers' interests. I mean, I agree with a whole lot of what she has to say, but I do think that the internet has created a forum where there is immense amount of damage that can be done with speech. And we've always said, people should have free speech, but you can't yell fire in a crowded theater. Okay? There's limits to it because of the damage that you can do. What we see are the people whose lives are disrupted or chaos is created because there is speech out there somewhere, whether it's an ex-girlfriend, an ex-boyfriend, it could be the SEC publishing an article, where speech is up there, accusations, negative reviews, negative comments, true or untrue. These days, it's very well recognized that you can get commercial advantage by posting false reviews about someone else's business who might be your competitor. There are lots of ways in which information gets put out on the internet, which, unfortunately, you can't get taken down. So you can go through requests to get certain trademark information down. You can get information taken down that is perhaps copyrighted, but an awful lot of the speech stays up. And so we start from the premise that the speech is likely to stay up. So what are the alternatives that an individual can have? Well, we look at the Streisand Effect from a different perspective, which is that if you begin to make waves, you will create a worse problem for yourself than not. So then what becomes your alternative? Suppose there's a bad article. Suppose that a former girlfriend, spouse, employer, employee, somebody who had a grudge against you posts something up on the internet which is negative. This happens daily. When you're young, pictures go up that shouldn't be taken. You can imagine all kinds of examples. And you have no ability to get that down. You can't really raise a fight about that online because that just calls more attention to it. And unfortunately, the more traffic there is about that on the internet, it causes it to go higher and higher up into the Google search results. So you need to have some other mechanism. And so what we do is we offer people an alternative. We are not going to get you a takedown because these folks are here telling us why takedowns don't happen very easily, and they're rare, and there are good reasons why you shouldn't be able to get a takedown easily. There is a high degree of, there's a strong need for protection of free speech. We do, however, have people who need to have information either addressed, taken down, or in our case, essentially suppressed off of the first couple pages of the internet search results. It doesn't take it down, but I think these days we all recognize that when you, whether it's someone new you're dating, whether it's somebody, a new contractor or a new professional who you're looking for, or a new business who you're thinking about doing business with, the first place everybody starts is with the internet. And if you go to the internet and you find negative information within the first few pages of the internet results, then you're going to not do business with them. You're going to take that into some consideration. So our products help people through a variety of techniques, some of which are proprietary and some of which are fairly well known, to either create, build what we call welcome content or more favorable content as a way of helping to suppress some of the more negative content. we see this ourselves. I mean, we might get a review as a company online. That's a negative review, and we realize we can't do anything with that review. We can't get it taken. If somebody has a complaint on Ripoff Report, Ripoff Report's not going to take it down. And so, how do we deal with it? So we see the frustration that other people experience, and what we try to do is to offer a way to minimize the negative impact that those kind of things might have on your business, on your personal life, while still on some level protecting the right of free speech, because it's not coming down, but you're allowed to also portray yourself in a way that you think might be a more favorable representation of yourself. What's that?
Suppressing what someone else says is totally different from how you portray yourself online. You said here's the things. I don't ask you to see the same thing.
Well, yeah, there is a very big distinction there. I completely agree. We're not suppressing it in the sense of taking it off the internet. You're not having it taken down. They have a right to speech. But one of the things that I think we start as a premise with is when you do a search online, you're not necessarily getting the most accurate information about these individuals. What you're getting is probably more likely the most popular information about the person, the most recent information about that person, the thing that most people are looking at about that person. We all tend to look at the negative stuff. So very often what comes up for somebody tends to be one person's perception of someone, one individual's criticism of someone, and it tends to be the more negative information that comes up first. So we're not stopping anyone from speaking freely. What we're essentially doing is saying that doesn't have to be necessarily all the information you see about someone when you do a Google search of them. And so by creating more positive, welcome content about somebody, you can essentially move that information down to where I, as the person being criticized, may think it's more appropriately placed, which is page 3 or 4.
Do you use automated tools such as computers that do searches so that the welcome contents goes to the top of the search result?
Meaning what?
Well, links or repeated searches for particular sites or businesses' particular sites in order to get the welcome content to go to the top of the search.
Well, we have a variety of proprietary techniques that we use. And frankly, I'm not an engineer, so I would be speaking out of turn if I tried to describe all of it, what you're doing. But a very big part of it is essentially there are a lot of ways in which you can create an image for yourself on the internet, which are legitimate things we all do. LinkedIn, for example, provides an opportunity to put a free profile up, which tends to come up on the first page of the internet results. You should have a LinkedIn profile. You should have one of them. But we do use a variety of techniques to help people's content show more favorably.
David, so you're down there kind of quiet. I haven't asked you any questions yet, but you've been kind of in the hot seat on some big CDA cases recently, and you've got a couple of clients that are pretty controversial in the Ripoff Report and the Dirty. Tell us a little bit about what's been keeping you in court recently.
Well, I will touch on that in a second, but what Chris was just saying, I just wanted to sort of close the loop. The really fascinating thing to me is I was listening to you, and what I hear you saying is this sort of policy decision of, well, the remedy for unpopular or negative speech is more speech, right? And that's always been sort of the default premise in America is we don't suppress something negative, we just talk through it, and we want more speech. And there is a real tension, and I was going to ask before I started talking, how many people in the room have heard of Ripoff Report? Everyone's heard of Google. And Professor Goldman, you're excused. Of the people that, and especially Professor Goldman's excused from this question, of the people that have heard of Ripoff Report, how many have heard something negative? So I'm surprised by that. Ripoff Report, I've represented Ripoff Report since 2005. I have litigated 40 or 50 or 60 cases for them, and in addition to other clients that I have, I've litigated, I think, more CDA 230 cases than almost any lawyer in the country. I don't know what Google's exact litigation docket looks like, but I deal with this a lot. And what really fascinates me is this sort of war between the different philosophies. There's people who take this I'm a victim philosophy, we have to help all the victims. Everyone who claims to be a victim is a victim, let's treat them special. And then there's the free speech folks who say, well, we can't make that decision, it's not our job, let's have more speech. And I'm right in the middle of that, and I'm really torn. And what's interesting to me is as I litigate these cases more and more, I feel like the tide is shifting a little bit. I have a case in Kentucky that some people might have heard about involving this cheerleader from the Cincinnati Bengals, who she's suing my client, thedirty.com, and in the middle of the case, it's a straightforward defamation case. She's suing over third-party content. I argued the CDA. The judge in Kentucky said, I don't know what that spells. I can't understand. And so the CDA has been taken off the table, which is an absolutely bizarre thing to have happen, to have fought so many cases where the judges understand and apply the law, whether they like it or not, and then have this one outlier case where the judge says, I'm just not going to go there. I just don't agree with you. So I'm litigating this case where I have a website client defending the truth of content they didn't create. And it is, I literally feel like I'm Facebook and I have Mark Zuckerberg sitting there as my client, and the plaintiff's counsel is yelling at him saying, can you prove this is true? Oh, no, you're going to owe millions of dollars. That's the kind of case that we're fighting. And I feel like there's a tide that's shifting a little bit. And I hope that case is going to trial a week from Monday for a second time. We hung the jury the first time. So we're having a retrial now. And it's just this bizarre thing where I feel like the tide is shifting. And I wonder if that's maybe a good thing. I feel like, you know, the way things have been in the last 5 or 8 years, there's been no relief or minimum relief for people that are victims, I'll use it in air quotes, victims of negative speech, right? And so you have this sort of cottage industry of the SEO people and the Reputation.com people, and they're out there fulfilling this need of, well, we got to do something different. We got to give them some remedy. So their remedy is you provide helpful content to them. I hope it's true. I don't know what your policy is for only limiting your help to people that really deserve it. But regardless of that, I feel like there's a shift that's happening, and it's interesting to me because I don't know where we're going to go with it. And you asked before, what are we doing? Ripoff Report has changed. A lot of the criticism towards Ripoff Report in the past was based on the fact that Ripoff Report never removed anything. There was other than copyright-based removal requests or things that were, child pornography or things like that, there are some areas that we don't allow or would remove if they didn't make it up. But everything else stays. We've now, because there's been so much litigation and so much hate, and frankly, people are just not giving up. They keep finding, or trying to find new ways to get around the CDA. We feel like there's a need for a pressure relief valve. And we adopted this program a couple of years ago. We call it the arbitration program, that's modeled after the UDRP process. If somebody takes your trademark and puts it in a domain name, you can go through an expedited process to get that back through what's called the UDRP. And we have a truth-finding arbitration process now that's modeled directly after the UDRP. The rules are almost they're not verbatim the same, but it works the same way. We now farm out this sort of truth-finding or litigation over accuracy to a third-party arbitrator who does an expedited process and at least takes a look at it. So we're not doing that judging role because we can't do that. It would be a conflict of interest anyway. And there's a third party that will do that. And I think that's great. It actually has really reduced the amount of litigation that we've had, so I'm sort of putting myself out of a job, I hope. But it's just this idea of, I think the market and the economic reality adjusts where we go with this. The law is supposed to be these outside fences that set the maximum limit of what you can do, but that doesn't necessarily mean that you should push it to that limit every time. So Ripoff Report, I think, and me especially, I listen to people, and I don't want to see people that are hurt by things, but I don't know who's telling the truth. So, for years and years, I've just sort of taken this hands-off approach, and now we're trying to change that a little bit. And I don't know exactly where that's going to go.
Have you seen a decline in lawsuits that implicate the CDA? I felt that the last few years, I ran litigation at Google for 3 years, and usually it was a letter or a phone call, and they'd go away. We actually didn't see that many cases that squarely implicated Section 230.
There are still a lot of demands that come through, a lot of legal threats, but what's happening is, in the old days, we used to tell people, they'd say, can you take something down? We would say no, and they would say, well, our only option is litigation. Now there's this different option, and we can at least some percentage, less than 100%, but some percentage of people now see that as, okay, this is a viable option. It's not free, you have to pay some fee that covers the arbitrator's time, but it's way faster, way cheaper than traditional litigation. And we like it, Ripoff Report likes it because we think there's less likelihood of collusion, and the arbitrators that we deal with are people that we know take a good, balanced approach. They understand the First Amendment, they understand that people can be victimized. And so, you know, it just, again, what's fascinating to me is this is ultimately a policy decision, and it kind of reminds me of the First Amendment is one thing, we have the Second Amendment, right? And every time there's a school shooting and there's a tragedy, and we look at, you know, children being shot in Sandy Hook or whatever, and people say, well, we've got to solve this. We have to, you know, no more blood, we have to do something about it. I know, let's take away all the guns, because that would solve the problem, wouldn't it? But as a policy matter, our country has the right to bear arms, and some people break the rules, some people don't, and there are casualties of that. And I think that sort of policy and those concerns are the same for me in the First Amendment context.
So I want to shift gears just briefly because time is going, but the issue of trademarks. And I personally have seen several cases recently where, because people are well known and they claim to have a commercial interest in their names, they're suing under Section 43A of the Lanham Act and saying that there should be a takedown or they have a lawsuit that doesn't fall within the CDA because of the exception for intellectual property claims. Anybody have some thoughts about that? I think you, David, and
Yeah,
Cindy.
I mean, I've seen a lot of those. I've litigated a few of those. I literally last week got a demand letter from Ryder Truck Rental, I think Ryder Truck, that said, there's a complaint about Ryder Truck, we own the trademark in Ryder, therefore you're infringing our trademark rights. And I wrote back, I think it was 2 sentences long, I was having a bad day, and I said to them, I said, Ripoff Report does not rent trucks, therefore we're not your competitor, therefore go away. And I, you know, I don't have time for that. The Lanham Act theory, I think, again, like I said, people are desperate for a remedy. When somebody feels attacked or criticized, they don't want no to be the answer. And that's what Chris's whole industry is about, is helping those people in one way. And you know, then there's this group of sort of plaintiffs lawyers out there who think, let's litigate our way around it. And I feel like it's, you know, pouring water into a bowl of spaghetti and watching it kind of percolate down, and they're going to find a way around this. And it's so, I think it's so destructive and counterproductive when you have the Streisand Effect coming up. This cheerleader case in Kentucky, this poor girl filed a lawsuit trying to take stuff down. For the rest of her life now, you Google her name, and she's there. You cannot use litigation to remove stuff from the internet. It's like trying to smother a fire with gasoline. And people don't understand that. And I think it's totally irresponsible when you see people filing lawsuits that shouldn't be filed in that way. And I always feel badly about it, and I try to like reason with them at the beginning, and I just get so much pushback.
Although your letter, such as you wrote to Ryder, is more likely to spark a lawsuit than anything.
I don't think so. I actually got
talking about the tone of the letter.
Yeah, well, that letter was actually a form letter that had like blanks in it. It said like insert email address here. It was a really lazy. It was a really lazy effort, and I actually got
enough of these that you've got it automated now.
No, the one you got, the one the writer sent.
Yeah, no, exactly.
Ryder's letter. I'm sorry.
And I got a follow up from a more senior person at Ryder who said, is there anything we can do to work this out? And I had some response for them. Again, I hate saying no. If you tell people no, they're just not going to accept that. So there ought to be more options out there. Finding out what those options are, that's where I think the future of this is.
Cindy.
Well, we certainly have had problems with it. We've certainly tangled with some trademark claims, and I think I disagree a little with David and his view about what needs to happen here, but he's certainly right that people who are upset will begin to try to throw whatever legal doctrine they can possibly throw at something to try to get it taken down. And trademark, because there is no clear intermediary protection or safe harbor for trademarks, it's a hard one. We handle a case involving the trademark for urban homesteading. And Facebook, they've taken down a bunch of Facebook pages where urban homesteaders, people who are growing stuff in their urban plots of land, talk about urban homesteading, and some have written some books and some other things. It's a trademark that never should have been granted. Frankly, it's purely descriptive. But the position of the intermediary is, look, I'm on the hook for this one. I can't just go on your say-so. So we've petitioned to the trademark office to get the trademark canceled. And we also did another case involving the word gamer, G-A-Y-M-E-R, for gay gamers, which went after a Reddit subgroup of gay gamers. And that guy just gave up. but he clearly still doesn't understand what the hell's going on, because he thought he had to give up his website when all we were trying to do was get to use the word "to." It was, I wish that he had better counsel than he appears to have, because he seemed to misunderstand the whole thing. And we wrote a blog post actually trying to explain to him why he didn't have to give up his website. But whatever, you can only do so much sometimes. But the, you know, the trademark process really is not designed for ordinary users, you know, ordinary people. I mean, one of the problems, you know, one of the global things that's happening now is intellectual property law, which used to be kind of a stakeholder game, right, where everybody was a commercial player and they go back and forth. Well, the internet has enabled a lot of people who don't have the resources or the sophistication and the you know, are insiders in this stakeholder game to actually have, you know, have rights that they are trying to exercise in this world. And so trademark is another one that really is not set up so that ordinary people can get protection in their use of trademarks.
There's actually some, as I learned recently in working on a case, there's actually some district court cases out there that hold that blogs that have ads on them are commercial speech.
Yep, the definition of
Just
commercial
blew my
is
mind,
crazy.
to be honest with you. And it's clear that partly the judges don't understand, and then also the advocacy is very poor.
Yep.
Because, you know, the law has been settled that newspapers are not turned into commercial speech because they have ads. So I don't see why there should be a different rule.
I mean, I think there's a reckoning coming in trademark law, you know, and a lot of people think there should be a, you know, a DMTA, a Digital Millennium Trademark Act. I am not a big fan of that model because I think the DMCA hasn't been all that great for users. It's been great. I mean, I'm all for an intermediary safe harbor, but I don't think the way that the DMCA cuts it is very fair to the people accused of copyright infringement as opposed to the accusers. And we have good law in trademark. The Koch case, Koch v. Doe's, which is somebody who's making fun of the Koch brothers, and we got a really good district court opinion. We just, EFF handled a case involving the Yes Men. These are people who do brand activism, right? So they do activism using other people's trademarks and you know, they were pretending to be the U.S. Chamber of Commerce, and then you know, announcing that they supported legislation around global warming, and then you force the Chamber of Commerce to go, no, we don't, and that's kind of the gag, right? The reveal. Nobody's really confused, as in like trademark confusion, like you might join the Chamber of Commerce because you misunderstood and thought they were on the different side of this issue. But nonetheless, you know, so the law is actually not bad. It's just that it's not really accessible to a lot of people. And so I think that focusing on, you know, creating a safe harbor for intermediaries in trademark law could stop this rush to use this theory to try to get what you can't otherwise get.
So let's do two things as we get toward the end, and that is this program is called Best Practices. So I want to talk about bad practices and best practices. So what I'd like to do is kind of go down to the table, starting with Chris, and we're going to talk about worst practices or mistakes, strategic errors that people make in trying to get stuff off the internet that is unpleasant. Do you have some thoughts on that?
Yeah, no, I have one that's sort of worst practice and the best practice together. The worst practice is your initial letter to someone be the flaming, you know, I'm going to do whatever it takes to get this thing down. Nasty, aggressive letter, because in very many cases that causes the Streisand Effect. It alienates the people that you're writing the letter to, who are ordinary people running a business, as opposed to sending, you know, a polite, well thought out request, or trying to reach out in some way that is non-confrontational, because people try to be rational in a lot of instances, and the worst thing you can do, whether it's not ending up with a takedown, but also having now put your flaming letter posted right after the complaint on ripoffreport.com, because there's a lot of those sites
which we are going to start doing that.
Yeah, I believe it. But there are a lot of sites that will do that, where the letter becomes itself part of the record and reason. So as the lawyers, you get angry clients coming in wanting to do something about the situation. I think that kind of letter is the worst way to start.
Okay, so David, why don't we combine it then? Worst practice and best practice.
Well, I need 4 hours to do it, but one of the worst practices is people that either get emotional and represent themselves and reach out in a completely inflamed state of mind. It's just the worst thing you could do. I always tell people, just calm down, sleep on it. Don't go read something negative about yourself and then deal with it that day. It's just a bad piece of advice. Also, people tend to hire lawyers that are like, your cousin Vinny, who is really good at DUIs, so he must know about the internet, right? And
Vinny won the case, though.
Yeah,
He might want a better one.
he did win the case. But I'm so tired of getting letters from people that say, I've read your discussion of the CDA, but that doesn't apply in Texas. And so bad practices are people representing themselves, people who hire lawyers that dabble. That's just so unhelpful. Where to find a good internet lawyer, God help you. I just don't have a good suggestion for that.
Well, we have a referral service, and we will help people on all sides of these debates try to find counsel. It's what we do as a public service. We don't charge for it. We don't charge anybody on either side of it. But we do try to help people find lawyers who at least have told us and know enough to know who EFF is and want to be on our list that they do. Again, we're not a clearinghouse as in, we can vouch for people, but we do have a list.
Number one best practice for me is keep it short and simple. Do not explain what defamation is, people. If you're sending a demand letter to a website like Ripoff Report, I can't tell you how many letters give me a whole treatise section on defamation law that I just don't even look at it ever.
And that the client paid for it.
Yes. Which makes me more angry on a personal level. The one-page letter that just says, and provide the information that I need. Give me a link to the page or some identifying information. I can't tell you how many letters I get that just say, there's something about Bob on your site, take it down. And I say, sorry, I don't know Bob. So be specific, but keep it short and be friendly.
State what's false about it, right?
You know what?
That's
For
a
me,
lot of times that's what's missing from these letters. It's not the law is there. People pack law, but the question they don't really establish what's false or what's wrongful or illegal about it.
From my perspective, I usually don't want to know, actually. I just want to know what do you need removed and what's your reasoning. Ripoff Report doesn't remove stuff. I have other clients that do, and they just don't want a long explanation. If you're asking for somebody to help you, keep it short and just say, why should you be helped? And that's all I need.
Cindy, where's strategic error or practice and best practice?
Well, I think the worst strategic error that companies make is they try to make all of these decisions without talking to their customers, the people who posted the speech. And obviously there are customers on both sides of this, right? But if you're the intermediary and you're hosting somebody's speech, your customer is not the person who's complaining, it's the person whose stuff you're hosting. And so giving them a real opportunity, not just a phony one, but a real opportunity to explain why they did what they did and take it down. Many people the vast majority of people, not the vast majority, I don't know, I've never done a hard analysis, but plenty of people will go, oh, okay, I'll just take it down, right? So, and letting them be the people who make those decisions as opposed to you is a really important thing to do in terms of empowering the people who you're giving a forum to. Giving them a fair shot, telling them what's going on, giving them enough time to get back to you about what's going on, having an actual counter notice process that somebody can use without a law degree. Those are the errors. I think the big number one error I see from companies is they forget that they have customers who should have a voice in this, and they don't build systems that allow that voice to happen. The best practices, we have worked with several companies who have stood up for their customers in the context of the copyright troll litigation, for instance. We stood with all people, AT&T, who I sued for many years for spying on their clients, who stood up, who was spying on for giving information to the NSA, who stood up in federal court and said, look, we're not comfortable with the fairness of the copyright troll processes. It doesn't seem fair to our customers. RiseUp.net, which is a little ISP, public interest ISP based in Seattle, recently did a whole litigation on behalf of its customers. In that case, they were trying to protect their customers' identities from a ridiculously overbroad subpoena. So the best practices is not only standing with your customers, but standing up for your customers, and it can be done.
And the last voice is Daphne, with worst mistake and the best practice.
So the worst practice, don't be perfect men. By which I mean, how you formulate your notice is really important. I'm probably not the only one who kind of cheered reading the CC bill opinion, which described this ridiculous notice process where it specified the URL on one document and had their oath on a different document and had the basis for the complaint on a third document, and the defendant was supposed to aggregate all this and figure out what to take down, and the court was like, that burden's on you. So be clear about, name the URL. Use a digital format so that the recipient can copy and paste the URL. Specify what law is being violated. Give your confirmed email address, things like that. And then sort of going to Cindy's point, I'm with you in spirit on the question of giving the accused a chance to speak up. But looking at web search and copyright alone, we're creeping up on 500,000 URLs a day that come down based on copyright notices. It was like 470 the last time I checked. And so scaling a process of having reasonable feedback from the accused and doing it in a time frame that's consistent with the DMCA is tough. So I think the more pragmatic variant on your recommendation that I would voice is try to figure out how to spot the dolphins. You're not going to be able to do it all the time, but do your best to figure out how to figure out when there is abuse going on so you can stand up for your users.
Great. Any questions? We'll take a couple extra minutes. Yes, Mr. Goldman.
We didn't talk about the state AGs. I'm going to call on Eric because I want to
We
say
might take
this.
the time. We should talk. We should take the time.
I have a question for Daphne. I actually think it's more important for this audience. So you said two things that were interesting. First, you talked about that the community guidelines aren't owned by the lawyers. And I understand that, but it seems like you then went on to say that they're really important to the lawyers, and they have lots of implications for the lawyers, and the lawyers are like, how big on them? My question for you is, to what extent are those community guidelines being misinterpreted? Not only by users who say, you said X here, but you treated me differently here, but by people like the state AGs. Certainly the meeting I was in last week, state AGs were saying, you keep saying all these things that you're doing for people and you're not, and we want you to. So to what extent are those community guidelines actually opening the door for people to come and say, we loved it, do more?
Mm-hmm. I mean, they do open the door. One of the instances of Muslims cases, the one in Israel, was a plaintiff saying, you have to take this down because I think it violates your community guidelines. So they do open that door, and as a legal matter, maybe we would be more pure and more theoretically defensible with no such thing as a discretionary removal. As a matter of product development and building a product that our users want to come and participate in, that's not a very viable way to go.
Well, we've been fortunate, right, because the courts have uniformly held there's no third-party beneficiary liability based on terms of service.
I still hear that argument being made. I heard it at the AG meeting last week. My co-panelists were saying that might work.
Right. Yeah. Well, Stratton Oakmont was rejected by the CDA. That was the whole point of the CDA, was to defeat Stratton Oakmont, which created liability because of representation of consumers. So, but people don't get it. They look at the terms of service and they go, well, look, Google or whoever, we're not picking on Google, Facebook,
Yes, you
whatever.
are. He is.
Whoever the site is, they're making representations that we are going to have a wholesome environment in which to function. People are not going to be able to say false things or unlawful things. But then we still make the choice. And then we say, well, we don't have any legal liability based on it. I think it's hard for them. So the state AG, just very briefly so people know, there's discussion on the state AGs. They're going to advocate to change the exception for federal criminal crimes for the CDA to include state criminal cases, right?
Yes.
And Cindy, you were...
Well, I just think people who are intermediaries ought to pick, people, this e-commerce best practices thing, I'm assuming I've got a bunch of intermediary and people who advise intermediaries in the room. CDA 230 will be not very helpful to you anymore if any state crime is an exception to it. Remember, states have criminal libel laws. States make all sorts of things criminal. We just got an injunction today against a state criminal law in New Jersey that made it a crime to do anything that in any way, shape, or form could facilitate sex trafficking. We got the injunction on behalf of the Internet Archive, because when you archive the web, you archive the good stuff on the web and the bad stuff on the web. So we already got a similar statute killed in Washington. There's another one, I think, in Tennessee or Kentucky or something. Tennessee one went down? Yeah. So now they're going to the state AGs to try to lobby to amend CDA 230 to let and if they amend CDA 230, it won't just be about child sex trafficking. It's going to be about all state criminal laws, and anybody who practices harassment, anything that's criminal, and unlike the federal criminal statutes, the states are general jurisdiction, right? There's all sorts of state laws. So I don't think CDA 230 is going to be any protection to anybody if this passes, and EFF and CBT and Eric has been part of it. There's a group of people who are trying to mobilize to make sure that this doesn't happen, and so this is my advocacy pitch to you guys, and if you care about your intermediary protection, we're coming upon the time where we might need to stand up and defend it.
Do you think also, maybe like Eric and you, Cindy, have to fix it, is that if the door gets open and there's serious legislation that starts getting into Congress by amending the CDA, that others are going to come forward and have their own special interests? Housing discrimination is one example, where they're going to say, well, we want to overturn the Craigslist case out of the Second Circuit on housing discrimination. There's a lot of vested interest of people that think the CDA is unfair.
That's right, and there's a bunch of people involved in people who are worried about religious, that religious state, people who, JDL has regular meetings about the problems that CDA causes because it allows people to say things that are not pretty about religion. So yeah, there's plenty of other interests, anti-discrimination people, who would like to see CDA 230 going away. But frankly, if you just make an exception for state criminal laws, those guys are all going to be happy, because there's some state criminal law that all that kind of stuff violates. So they will win. Those other forces, I think, will come out. And I think it's going to be important for Silicon Valley folks to stand up and explain what happens if you make intermediaries responsible for everything that gets said on those sites, and what that means for for businesses and for this future evolution that this technology has enabled. I mean, nobody gets to speak on the internet without at least one intermediary, except for maybe Google, because now they own all the way down to fiber.
Any other questions? Otherwise, we're finished. And the boss is saying, shut up. Thank you very much.